everybody. I'm Kate O'Regan. I'm the director of the Bonavero Institute of Human Rights, and you're all very welcome to this, the first of a series of judicial conversations in which we're going to explore issues relating to the separation of powers. We're very fortunate indeed, I think, to have, as the very first judge to engage in one of these conversations, Judge Paulo Pinto de Albuquerque. Judge Pinto, or Paulo as he's instructed me to call him, has been a judge of the European Court of Human Rights since 2011. Prior to that, he was a judge on a range of courts in Portugal. And I have to say that we have a neighborly connection because Judge Pinto was born in Mozambique, in Beira, Mozambique, and moved back to Portugal as a small child. He tells me he hasn't been to Mozambique since, which I think is his loss because it's a really beautiful country. And it gives us me a sense of connection to him. So as I've said to you, the series of these conversations is really to explore these really difficult questions of the separation of powers in modern human rights law. They come up before courts at every tier, but of course we know about them particularly in relation to courts at national level. We haven't really got very much theory which will suggest to us what the relationship is for supranational courts, for regional courts, and that's why I think it's really interesting to have this conversation today with a distinguished member of the European Court of Human Rights, and one who has very recently written, I think, what might be described as a strong and perhaps provocative dissent in a judgment called Hutchison versus the United Kingdom, which we will talk about a little more. How we're going to run this program is that Judge Pinto is going to make a few remarks initially, thinking about the theoretical issues that underpin the job of judging in the European Court. And then we're very fortunate to have, in fact, a former Oxford person here, Jeff King, who has written on these issues and written on issues of relationships between courts and other arms of government in a very distinguished manner. We're delighted you came up from London, and I know you've had some travel difficulties getting here, so we're delighted looking so cool and calm as well. To be one of the discussants. Unfortunately, Aileen Kavanagh, who's going to be the other discussant, has been taken ill this morning. So I think Jeff and I will, between us, put a range of questions to Judge Pinto, and we will then, after that, open it up to the floor for questions. Judge Pinto, thank you very much.
Thank you very much, Kate. It's a pleasure to be here to address this audience. I have two preliminary words. One of gratitude to the Institute for the invitation, of course, and the second, a disclaimer. I'm going to talk in a personal capacity, and of course the positions that I'm going to take do not bind the court, they only bind me. The topic that was given to me, and I think the main issue that will be addressed during the conversation that we are going to have is the existential crisis of the European Court of Human Rights. Is there really such a crisis? Is the court facing such a crisis? I think it's stating the obvious that the current relationship between the United Kingdom and the European Court is a strained one, and this fact has contributed significantly to the present existential crisis of the court. But why the strain? There are three political critiques frequently leveled against the court, all encapsulated in the idea that the Strasbourg judge acts as a subsidiary legislator, as the Germans say, an Ersatzgesetzgeber. The criticism is directed to the working methods of the court, the status of the judges, and the lack of consideration for the British exceptional situation. The argument drawn from the working methods of the court is the following. Judicial activism leads the court to a mission creep. The court's attempt to aggrandize itself is visible in the invention of new rights and the enlargement of its own powers. The court's micromanagement of cases threatens democracy and state sovereignty, since governments lose control of the convention and domestic authorities are sidestepped and discredited. The argument based on the status of the judges states that the Strasbourg judge lacks political legitimacy to act as a subsidiary legislator. The problem of the unaccountable judge is aggravated by the fact that some judges come from allegedly second-class democracies. The undemocratic reality and the less democratic pedigree of some contracting parties to the convention taint the court's reputation and the case law's authority. The British exceptionalism argument goes like this: Parliament is sovereign and domestic courts must defer to it. And the same applies a fortiori to international courts, since the parliamentary sovereignty is protected by a dualist system of relationship between national and international law. As Lord Neuberger put it, the idea, and I'm quoting him, the idea of courts overruling decisions of the UK Parliament, as is substantially the effect of what the Strasbourg and the Luxembourg courts can do, is little short of offensive to our notions of constitutional propriety. End of quote. The second type of critiques made against the court is more complex, since they pertain to the nature of the subject matter that the court deals with, namely the rights and freedoms enshrined in the Convention. They turn around the motto that there is a conflict between genuine and fake human rights. Three claims are made. First, human rights are residual civil liberties which serve ultimately only minorities, not the majority of citizens. The Convention is portrayed as the villain's charter, not as the Bill of Rights of the common man on the street. Furthermore, social rights, or a social reading of human rights, is totally inadmissible. First, because these are not enforceable rights, not truly enforceable rights. Human rights only imply negative, not positive obligations, and certainly not a budgetary cost. The transformation of the Convention into a disguised social charter betrays its nature. The second claim is that human rights result from originalist, true interpretation, not an evolutive, abusive interpretation of the Convention. The true interpretation of the Convention is based on the travaux préparatoires and eventually also on the contracting parties' law at the time of the drafting of the Convention. Soft law is not law and should not be taken into account, not even as a contextual element of interpretation of the Convention and its protocols. Third claim, human rights are truly homegrown, not foreign rights. There are no universal human rights. Universal human rights are indeed foreign human rights, imposed by alien judges who lack sensitivity to domestic traditions. The defense of your homegrown rights imposes a sort of skepticism regarding international law and bodies. What is the response to be given to these claims and critiques? Well, the response to these claims, in my view, requires that we go back to fundamentals, to the basics, and recall what the court was built for. The idea from the very start was that the Convention creates obligations of positive and negative nature for states towards all individuals within their jurisdiction. It's much more than a multilateral agreement on reciprocal obligations of the states. It's a really law-making treaty, not a mere contract treaty. The Commission, right from the start in 1960, said so. It expressed this idea when it affirmed the objective character of the Convention. It said, and I'm quoting, the obligations undertaken by the contracting parties in the Convention are essentially of an objective character, being designed rather to protect the fundamental rights of individual human beings from infringement by any of the contracting parties, than to create, being designed rather to protect the fundamental rights of individual human beings from infringement by any of the contracting parties, rather than to create subjective and reciprocal rights for the contracting parties themselves. So from the very start, the convention was seen as a text that should be read in the light and in harmony with other international law and soft law. Ever since Golder, this has been the method, I would say the correct method of interpretation of the convention. So from the court's perspective, there is no methodological difference between the interpretation of international human rights law and other international law, or between contractual and lawmaking treaties. And therefore, the court assumes that the same interpretative methods can be applied in both fields of international law. This, of course, this methodology was warranted by the court's cardinal principle of interpretation, the interpretation according to present-day conditions, the evolutive interpretation of the convention, which was inspired by American and Canadian constitutional law. If you read carefully the leading case, Tyrer versus the United Kingdom, you easily reach the conclusion that the evolutive interpretation of the convention was intimately linked to the need for a consensual reading of the text based on the consideration of the domestic legal framework of, and I'm quoting, the great majority of the member states of the Council of Europe, end of quote, and ultimately of the common heritage of political traditions, ideals, freedom, and the rule of law to which the preamble makes reference. The foundational principle of evolutive interpretation has been recently put at stake in Hassan versus the United Kingdom. Contrary to the government's position, the Grand Chamber affirmed that international human rights law applies to international armed conflicts concurrently to humanitarian law. But it went on to admit, as pleaded by the government, that humanitarian law, namely the Third and Fourth Geneva Conventions, relating to internment, may be used to qualify, in practical terms, to weaken international human rights law standards. On the basis of an alleged subsequent practice of the contracting parties during international armed conflicts outside of Europe, which did not use the derogation clause of Article 15 of the Convention in order to detain people indefinitely in such war scenario, the Grand Chamber assumed that all contracting parties had proceeded to an implicit review of their own contracting commitments, of their own convention commitments, and enlarged the exhaustive list of detention grounds of Article 5. The principle of evolutive interpretation of the convention was turned upside down with a view to include in Article 5 a new ground for detention, namely internment under international humanitarian law. The practical consequence being that in cases of international armed conflict, where the taking of prisoners of war and the detention of civilians who pose a threat to security are accepted features of international humanitarian law, Article 5 can be interpreted as permitting the exercise of such broad powers, and the looser standards of review of detention of the Geneva Conventions will apply. Hence, review of such detention should take place by a competent body and not necessarily by a judicial authority. In other words, evolutive interpretation of the Convention may now permit a regression in terms of human rights protection in Europe. This evolutive interpretation of the Convention was also from the very start of the court's case law intimately linked to soft law, to the hardening of soft law. If you read carefully Demir and Baikara, the landmark case on Article 11, you will easily conclude that for the purpose of interpretation of the Convention, the legal relevance of human rights standards set out in other treaties and conventions depends neither on the number of their respective ratifying parties, nor on the number of Council of Europe member states bound by them, and nor even on the fact that the respondent state ratified them. In that particular case, the argument made by the court was that the standard set by Article 6, paragraph 2 of the European Social Charter, which Turkey had not ratified, could influence the interpretation of Article 11 and should influence that interpretation. Thus, under European human rights law, hard law is profoundly interwoven with soft law. The court's soft law and social rights friendly stance has now been questioned in a recent case, National Union of Rail, Maritime and Transport Workers versus the United Kingdom. The court acknowledged the wealth of international law material relevant for the case. Nonetheless, in spite of this, in spite of the fact that the court acknowledged that the analysis of the interpretative opinions emitted by the competent bodies set up under the most relevant international instruments mirrors the conclusion reached on the comparative material before the court, namely that the UK outright ban on secondary industrial action is totally out of line with the international trend calling for a less restrictive approach, the court nonetheless preferred to underscore the distinct character of its review compared with that of the supervisory procedures of the ILO and the European Social Charter, and to conclude that in this legislative policy area, the respondent state enjoys a margin of appreciation broad enough to encompass the existing law on secondary action. So no violation of Article 11 of the Convention was found. Probably the most telling example of another major danger facing the European human rights protection system is the unfortunate Irst saga. It is the danger of contagion of bad examples of non-implementation of the court's judgments. And this domino effect is visible with many other countries. 13 years have passed without implementation of the Irst judgment, this omission being aggravated after 2010 by the delivery of the pilot judgment in Greens and MT. In spite of the court's crystal clear indication that the blanket prohibition existing in UK law constituted a systemic failure which required the adoption of measures of general nature, none were adopted even after the Grand Chamber itself nuanced the court's position in Scopola in 2012. Both the UK rebellion against Irst and the court's backtracking from foundational principles of interpretation of its own case law have had a quite remarkable enduring negative effect on the efficiency of the European system of human rights protection. And the best example of that, of course, is the situation in Russia. After the shockwave sent by the 2012 Konstantin Markin Grand Chamber case on the right of servicemen to parental leave, which was perceived in Russia as an interference with the organization of the Russian army, the 2013 Anchugov and Gladkov judgment dealt with the exact same issue of Irst, the ban of voting rights of prisoners, but this time with the particularity that the ban was based on a constitutional provision, Article 32, paragraph 3 of the Russian Constitution. That did not hinder the court from repeating the finding of a violation of Article 3 of Protocol 1, which would logically entail a constitutional reform in Russia. No such thing happened. On the contrary, in July 2015, the Russian Constitutional Court judgment on the federal law on the accession of the Russian Federation to the Convention affirmed that the judgment of the European Court is not enforceable in Russian territory if the Constitutional Court finds that it contradicts the Russian Constitution. Since there was no legal framework for such a finding, the Constitutional Court suggested that the Duma approve legislation to create a special legal mechanism to ensure the supremacy of the Constitution in the implementation of the European Court of Human Rights judgments. Such interpretation of the Russian Constitution was enshrined in December 2015 in a law on the Constitutional Court powers approved by the Duma, which established the Constitutional Court power to declare rulings of international judicial bodies non-executable in Russia if they contradict the Russian Constitution. In April 2016, the Russian Constitutional Court applied this new law for the very first time and decided that precisely Anshugov is not enforceable in Russia. The 2016 Constitutional Court judgment only worsened the present existential crisis of the court. If it is true that the vast majority of the court's judgments are implemented with more or less delay and precision, the fact remains that in a vast growing number of cases, some states are not willing to go along with the court and oppose directly or indirectly any kind of implementation of its judgments. In the case of Russia, there are now pending 1,573 non-executed judgments. 1,573 non-executed judgments. Of them, 204 in leading cases, among which the famous 2014 Yukus judgment that set highest ever compensation amount in the history of the court, 1.8 billion euros to be paid to the applicants. The question is, how long can we cope? For how long can we cope with this trend? If we do not reverse this trend, the court will soon become an irrelevant institution within the Council of Europe, and we know what is the fate of useless institutions. My point today is that the court is really faced with an existential crisis, and it's up to us, first of all lawyers, but also as citizens, to recall what the court was built for. The court was built to guarantee peace, democracy, and human rights in Europe. For that purpose, it established a specific mode of legal reasoning. Since its early days, the court has always sought for a purposeful, pro persona, objective, open-ended, autonomous, evolutive, effective, and consensual convention interpretation. The court's golden rule of interpretation rejects a formalistic, subjective, self-contained, literal, originalist, indubiomismus, and sovereignistist convention interpretation. Let me close my initial remarks with a reference to a debate between Chief Justice Frankfurter and Rawls. Once Justice Hughes said to Justice Douglas, and I'm quoting, "You must remember one thing, at the constitutional level where we work, 90% of any decision is emotional. The rational part of us supplies the reasons for supporting our predilections." End of quote. Inspired in these words, Justice Frankfurter concluded, and these are his words, the Constitution is the Supreme Court. Rawls' rebuttal was vehement and straightforward. The Constitution is not what the court says it is. Taking into account this golden rule of interpretation that I've just mentioned, we can say today that, at least in Europe, Rawls is right. Thank you very much.
Thank you very much. much indeed, Judge Pinto, for a fascinating account of your argument about the crisis that the court is facing. I'm going to move the podium so people over there can actually see the other people, and then I'm going to ask Jeff King to make a few initial remarks in response, and then we will move into a conversation.
It's an honor to share the podium with two distinguished jurists from whom I've learned a lot. I should say that I found Judge Pinto's dissenting remarks in the Hutchinson case to be so important that I assigned them both in a tutorial at UCL and also it's very relevant to the exam, which hasn't taken place, so I can't say just how relevant it is. But I think it's a very important riposte to a trend that's happening in the United Kingdom and elsewhere, and it's a pleasure to be able to engage with some of the comments that were made. Most of what Judge Pinto has just said I agree with, some of which I think some of the characterization of the constitutional tradition and the discussion in the UK, I think is not entirely representative of the legal community here. And by that I mean there is a particular salience to comments that are made by judges such as Lord Sumption, which do not represent even a simple majority, let alone the vast majority of the juristic community here. For instance, the reference to the idea of originalism is very unique to that judge and to some tabloid-type commentators and to some comments that Lord Hoffman has made, for instance. If you look to the jurisprudence of the United Kingdom courts, they have squarely rejected that interpretive approach and embraced purposive statutory interpretation. And I think it's rarely is the approach of evaluative interpretation challenged in the UK. In fact, when the white paper for the Human Rights Bill was laid before Parliament, it mentioned evaluative interpretation and suggested it would be an exciting chapter in the UK's legal future to be able to participate in the development of those rights. That's a minor comment. I'd like to comment on a more significant matter, which is the suggestion, the very, very clearly argued and persuasive, I'd say, comment that what is happening in the United Kingdom right now is that the practice of the courts here are pushing back issues to the Strasbourg court, essentially rebutting the interpretations that the Strasbourg court has offered, is part of the existential crisis. It's contributing to that crisis directly from a very senior member of the system. I think that what I'd like to suggest is that we can see what's happening, at least within the courts, if not the political system, as being somewhat more defensible, I'd say, or at least it can be seen in a more charitable light. And I think it's because of this. I don't think that the Strasbourg court can claim consistently and always to have absolute and unique interpretive control over the meaning of the European Convention. The reason I say that is that I don't think it's a Supreme Court for Europe, and that is not because it does not actually have final, ultimate interpretive authority for the Convention. Of course it does, that's indisputable. But the reason why I think it should not insist on an absolute tight grip on each of its judgments in the way that a national Supreme Court might do over its lower courts is because the complexion of the Council of Europe is not like that of an ordinary nation state. It's not like that of a federal state either. It's not a federal order in two very important sentences. One is that there's no federal legislator with a general jurisdiction at the top. The Council of Europe's political functions are analogous in some ways, but they are not strictly analogous. It also doesn't have, in a normal nation state, a large number of subunits that have their own national legislators, which have distinct political foundings and thousand-year cultural and political traditions, which don't always equate with one another. That is the system in Europe. I'm sure Judge Pinto knows this much better than I do. I make that point for the following reason. It's very possible that in such circumstances, when adjudicating the political and social policy of so different polities, that a supranational body like the European Court of Human Rights will occasionally simply get things wrong, either about law or policy or social facts. Now, this has to do both with the physical and political distance from local affairs, but also to do with the speed at which complex decisions about these things need to be made. This is not a question of legitimacy. The states have accepted the jurisdiction of the court. It's rather one about epistemic competency and institutional capacity. I've always taken that to be the best justification of the margin of appreciation doctrine. That would mean the Strasbourg court, in my contention, would need to show some restraint for these types of reasons. I think most judges on the court, and I believe Judge Pinto also, would accept that proposition stated so barely. But of course, we all know that if the court showed restraint all the time, if it really took very, very seriously the point I'm making, that it would be abandoning its mandate. That is, to create a body of human rights law for all of Europe. So how can we have a vigorous supranational court that may do things like write the penal policy for Britain, and at the same time admit the obvious, that even judges in that court have a comparatively weak understanding, comparatively, of a country like Britain's penal traditions, its criminal procedure, and its substantive criminal law? How can we have both a vigorous court and one that we have to admit suffers from a certain degree of epistemic disadvantage? This is a problem for all courts, but it's particularly a problem for the European system of human rights law. One way I think we can have a vigorous court while also admitting these epistemic and institutional capacity limitations is to have a doctrine that is very much like the one we now have in the United Kingdom. That's one which allows national courts to invite the Strasbourg court to have a second look at an issue. That's basically the law that was affirmed in Chester and that evolved up through Horncastle. When there's a clear and constant line of jurisprudence from Strasbourg, it is the duty of UK courts to apply that line unless they believe it's fundamentally inconsistent with a feature of the UK legal order. In that case, the courts are allowed to invite the Strasbourg court to have a second look at it, to think again. That's the language of Lord Sumption's comment on this line of jurisprudence in Chester, and I think it's the most accurate one. So in this fashion, what is happening is not quite the same as Parliament refusing to go along with European human rights law, as we see in the Hearst case. I fully agree with your comments on Hearst. I think it's a travesty that that's been allowed to happen. I don't think that the legal doctrine which allows the courts to invite the Strasbourg court to have a second look is in quite the same category. What we would need, I think, in this situation is to distinguish between what we might simply call legitimate disagreement and illegitimate disagreement, and what to do with it. I think political pushback is generally inappropriate. You can make comments, but you have to follow through on complying with the law. That's what the rule of law requires. But a judicial invitation to reconsider a line of jurisprudence, I think, is not in the same category. That's different. It comes from judges which have the institutional independence, and they show proper respect for the regime of law generally. I think at the same time, obviously, the invitation has to be exceptional rather than routine. And it's precisely here that Judge Pinto has said that these exceptions have the tendency to accumulate very quickly. I think that is very much a possibility. However, it is also the case that in the British legal order, you'll have these idea of we'll allow rare cases where we'll depart from a line, and they work relatively well. So it is a question for Britain whether that would be unworkable. Whether it's unworkable in all of the Council of Europe is another question. I think, thirdly, that the second look, upon a second look by the Strasbourg court, the UK courts should relent. And I think so far they generally have relented. Lastly, I am not suggesting in any way that the Strasbourg court should do what I think Judge Pinto fears, which is that it might bow to political pressure. Perhaps that was the case in Hutchinson. I happen to agree with Judge Pinto's disposition of the Hutchinson case. I think he was right there. And perhaps it might have gone the way it did because it was a moment in UK Strasbourg relations that was particularly low, possibly the nadir. But I also think at the same time that the Strasbourg court should be willing to accept the possibility of being wrong. And I think especially when the consequences are enormous. And the Animal Defenders International case is exactly such a situation. Had the Strasbourg court been wrong about the possibility of having a workable exception to the ban on political advertising on the broadcast airwaves, we could have had a fundamental transformation of the way that political system works in the UK, one that may have favored wealthy groups which would quickly be founding NGOs that would be indirectly supporting candidates that could transform politics here much for the worse. So those are the only comments I wanted to make. I don't feel that fundamentally I disagree strongly with Judge Pinto. I recognize the very serious existential problems that are being pointed out, but I would like to suggest that I think perhaps more charitable light can be cast on the very delicate operation that the UK Supreme Court has tried to manage, which is to reconcile these epistemic issues that I'm talking about in a genuine way, in a way that's faithful to the purposes of the convention, with very sometimes justified arguments that the case law in Strasbourg doesn't quite understand exactly how it works here. That's all I'll say for now. Thank you.
Could I just ask you, before you sit down, if you might also consider how that proposition that you're making might work for the court across all its members, and whether that, in fact, would be fundamentally destructive of a common court purpose?
So I was thinking about this this morning. I think that if it were quickly a doctrine were formed whereby a court could ask the Strasbourg court for a second look, and it could either perhaps certify a question that could go to the court. I don't know in civil procedure terms how it would work. And then it be established that once the Strasbourg court has looked again and ruled, then that's it. I think that is workable, and that would create a system where the buck would stop in Strasbourg. But some of these epistemic problems I've been mentioning would also be addressed. And it's sufficiently clear, and hopefully it could be arranged in such a way that it wouldn't disadvantage claimants. You might also have jurisprudence saying that no claimant's rights shall be finally determined until that conversation has taken place. I think that could be, my instincts are that it could be viable, but I don't think my instincts on European juridical politics are anywhere near as refined as Judge Pinto, so I'll sit down having said that.
Well, thank you very much, and I'm sure that Judge Pinto might like to respond to that question, to the propositions put by Jeff immediately.
Yes, well, the main point made was that the court can get it wrong, and therefore it must acknowledge the need for this this proposed system of reconsideration on the basis of a judicial decision taken at the national level. I have 3 points to make here. First, this assumes that the court is not provided with the best lawyers in Europe, members of the registry extremely well prepared, and among them, of course, British lawyers who have a profound knowledge of national law. So I cannot accept the assumption that the court has comparatively a weak knowledge of domestic law. First. Second, this also assumes that the court internally does not have a system of review, which is not true. The decisions of the chamber can be appealed to the grand chamber. If a government is not happy with the decision of a chamber, it can go to the grand chamber. So there is already a system of invitation to reconsider decisions at the level of the grand chamber. These two assumptions are really lacking on reality. The reality is that we do have, and we fortunately have, great lawyers working with us. Of course, on top of, this is obvious, on top of the input of the national judge. We cannot forget that decisions are taken after a national judge takes a stance on the issue at stake. So the knowledge that upon which the court decides cannot, in my view, be presumed to be insufficient. And adding to this, the fact that there is a system, an internal system, which provides governments to really to ask for reconsideration of previous judgments of the court, and the court itself has said, and it has case law on that, well-established case law on that, that it can review its own case law at the level of the Grand Chamber. So taking into account the mechanism that is working in Strasbourg, I don't think that there is really a need for these other, I would say, really odd additional judicial invitation to reconsider decisions of the court. In fact, what this ends up doing is really to allow domestic courts to put in question the authority of the judgments of the court. That is the problem. That is the issue. And to pick and choose which judgments they want to implement. This, of course, downgrades the judgments to mere recommendations. The legal force of the judgments then is really in itself denied. And the risk is that, of course, if one member country, especially one founding father of the system, starts to do this, this will be replicated by all other states sooner or later, because there is this very strong temptation that if I'm not pleased with the judgment, I just have to cite the British example. In fact, that's what happened in the Russian case with the Russian Constitutional Court. This exceptional use of the rare occasions argument, Horncastle argument, in my view, is extremely dangerous, because it opens the door to really to the cherry picking of judgments, and ultimately it all boils down to the legal force of the judgments. We now have the Constitutional Court of Russia and also other constitutional courts, namely very recently the Constitutional Court of Italy, questioning the legal force of judgments of the court. If this goes on like this, the future is not bright. The future of the European human rights protection system is really in danger. Let me recall that it was not like this during the 70s and 80s and 90s, I would say. Just to recall, because it's important to recall history. When Malta was confronted with the Demicoli judgment, which basically said that the criminal law competence of the Maltese House of Representatives on the breach of privilege, which, by the way, is long-standing common law institution, breached Article 6, and this was based on a constitutional provision of Malta, this criminal law competence. What did they do in Malta? They simply reviewed the Constitution. Another example, when the court found in Open Door against Ireland in '92 that the prohibition in Ireland of provision of information on abortion in the UK, based on a strict interpretation of a constitutional norm protecting human life, was in breach of the convention, what did they do in Ireland? They made a constitutional review, constitutional reform. So this is not new. The problem is not new. The problem has been there. We have been faced with this problem in the past of sensitive, extremely sensitive issues, some of constitutional nature, that raise the most delicate political debate at the national level, triggering eventually even constitutional reforms. These problems have always been there. And the reaction was, as I've seen, as I've mentioned, as we have seen, very cooperative reaction, namely by addressing the issue that the court had identified as a problem. The problem really started, I would say, with Sejdic and Finci against Bosnia, the judgment which put in question another constitutional provision, the provision in the Bosnian constitution based on the Dayton Agreement, which prohibited members of the Roma and Jewish minorities to be elected as House of People's members and as presidents of Bosnia. Of course, this, again, an extremely sensitive issue, which raised an enormous debate, political debate in Bosnia and in that part of Europe, which led to no solution until today. We still have a judgment of the court, a Grand Chamber judgment, which is not implemented. And that was, I would say, the beginning of this whole series of important judgments not being implemented at the national level. My point is the following. The problem is not new. I'm not convinced that the solutions that provided for quite smooth cooperation between the court and the national authorities in the past do not work today. They can work today. They have worked in the past. They can work in the future, and there's nothing to oppose to these solutions. They are based on the case law of the court. I think it's more a question of political will. Is there a political will to make this work, or are we really not willing to trust the court? That's the point. And of course, things can change, and the political majority in some countries has changed. In some sense, they have become more reluctant to accept an international court, but that was the deal from the very start. That the international court would have a saying on important national issues. If you read Professor Lauterpacht's intervention when he addressed this issue, the statement is very clear. We have to expect that this court will interfere in extremely important national issues. We will have this court interfering, and it's a good idea that this court interferes from the outside, without any stakes on the political national fight, because it's an independent view, because it's an European view, it's a collective body which provides a different perspective. And that was the purpose of the system. So if it worked during the 70s and 80s and until the late 90s, why not today? I feel that the point is more of lack of political will that really is putting the strain on the court.
Well, thank you very much indeed, Judge Pinto, for a very engaging and feisty defense of your statement that the court is in a crisis and explaining why you think so. I know there are many people here who are real experts on the European Court and its jurisprudence, so I think it would be appropriate now to open it to the floor. Just to remind those of you, it would be helpful if you could just introduce yourselves. We are recording the event, so bear that in mind. And if people could just indicate if they would like to have questions, it could be over a whole field.
My name is Ed Dates. I'm an academic from the University of Leicester. Thank you for the opportunity to be here. May I say, with respect, I think you're doing a great disservice to the role of the courts in the UK. I would agree with Professor King. They've been very loyal, actually, to the Strasbourg Court in their jurisprudence. Some would say too loyal. I can't think of any case in which they've not followed the clear and consistent jurisprudence of the Strasbourg Court. There have been opportunities to enter into dialogue with it. So I don't see the case that the UK courts are being resistant in a principal way to Strasbourg at all. I agree with you, of course, it's a political matter, and I don't defend the non-execution of the Hearst judgment, of course. It was in the political arena. So, for example, in the case of Hutchinson, your stirring dissent in Hutchinson recently, the UK Court of Appeal did accept the Article 3 standard of relevance. It disagreed, of course, on the enforcement of it in the national context in terms of what the national law meant. My question, though, if I could put it, is this. When you say we need to go back to the origins of the Convention, and that this is the way to, if you like, rejuvenate and save the Convention, you said the court was built in the 1950s on the notion of peace, democracy and human rights and a collective enforcement vision in relation to that. I agree. I've looked at the history of the court fairly closely. The notion of collective enforcement is at the heart, really, of what the Convention is about when you pin it back. And that might also be a problem, though, because if you look at collective enforcement, people then start to say, well, if this Convention really is about peace, democracy and human rights, where does extraterritorial reach of the Convention fit in that model? Is Hearst really part of that dynamic? Is Hutchinson even? I'm not saying it's not, but the more the court moves into what might be regarded as controversial constitutional line territory, the bigger the questions can arise as to where the authority of the court rests to enter into that field. And when that scenario arises, the consent on which the Convention rests, that consent of the states, may be threatened. And I wonder if aspects of that are being witnessed in the crisis to which you refer to in the UK at the minute. I'm not saying it covers the whole picture because the tabloid press are disgraceful in their approach. So my question comes back to, actually, if you look to the origins and the real core meaning of the Convention about collective enforcement, doesn't that actually start to raise questions about some of the judgments itself that the court comes up with, if they can be equated with the type of constitutional court model which I think Professor King was also alluding to.
Thank you very much. I might take one or two more questions and then give the judge an opportunity to respond. Are there other questions? Yes, Judge Sharp. I think we'll probably hear you.
I'll try to speak up.
Okay, great.
My name is Robert Sharp. I'm a judge from Canada, and I'm certainly not an expert in European human rights jurisprudence. Let me offer an outsider's perspective on what you've said. Many, if not quite all, of the arguments you've made, reciting the critiques of the court, I hear in Canada, and we're operating in an international system. The charge of judicial activism, self-aggrandizement, assuming the legislative role, villain's charter, all of those arguments are made against what our court is doing in Canada, which leads me to think that perhaps some of this is not so much about the international court, it's just about inherent in the adjudication of human rights. Now, we don't have the enforceability issue because generally judgments are respected. But to turn to Jeff King's point about a second look, that actually happens with some considerable frequency in Canada. And it happens in a variety of ways. One way is very often a judgment striking down a piece of legislation is followed by another piece of legislation. Not quite the same, but often quite similar. And the court ends up taking a second look. It often happens because of cases working their way up through the system saying, look, that judgment poses these problems, and our Supreme Court will take another look. So I think there's actually something, to my mind, quite attractive about the idea of a second look. We've talked about the inherent limits of adjudication as a way of making law. Often it is a good thing to have a second look, and a dangerous thing, I suggest, for courts ever to think that whatever they've said is the last word, period. So from an outsider's perspective, there's a different way of looking at it.
Thank you. One last question in this round? Yes, Leora.
I'm Leora Lapis, and I'm a law fellow here. Thank you for my question is actually directed to Jeff, which is how do we work out where the rare occasion is legitimate or illegitimate? So I'm not entirely in agreement with yours or Ed's view of the sort of sanctity of English jurisprudence and all its purity. I thought that the Attorney General reference case was, your decision was really a fudge, and on any reading of that may be the case that the UK wishes to express that, but on any reading I thought Strasbourg was absolutely wrong to backtrack on that question. And we'll talk about that more, just on the content of the right and on the intention. So this was on this domestic decision relating to life sentences that led to the Hutchinson question. And so, as much as they accepted the Article 3 point, the whole point of intentionality, the whole point of hope, and the whole point of knowing at the outset of the sentence was really not addressed. So, would you put that into the category of the legitimate decision or the illegitimate decision? And this is the technical issue that I'm having some difficulty with, and not least because the second look argument leads us to this massive expansion. I see the backlog in Strasbourg and suddenly doubling, and I think, wait, another one, another look. So we need more kind of clarity on that particular line.
Thank you. Paolo, would you like to respond?
Yeah, if I may start with this question, with all due respect, of course, I think, and I've written that, so it's nothing new. The response given by the Court of Appeal in Hutchinson or in Newell is not really enlightening. The court took a very clear position, saying that there was a lack of clarity in the British legal framework because Bieber said that the Article 3 reading of the compassionate grounds should be followed by the Secretary of State. The court in Strasbourg said that Bieber was not enough, concluded that there was lack of clarity of the legal framework domestically. And what happens? We have the reply from the Court of Appeal in Newell saying, well, no, the term exceptional circumstances is of itself sufficiently certain. Full stop. No less, no more. That's it. And we continue to read and find no explanation of what this means. In fact, at the end, they even say that we find it difficult to specify in advance what such circumstances might be, so that they themselves acknowledge that they don't have a hint about what these exceptional circumstances are about. And yet, in Winter, the indication was given clearly in very blunt terms. There must be a mechanism that from the outset permits the prisoner, the lawyer, the citizen to know what are these circumstances. So in my view, this really is not a dialogue, it's a monologue. And it's unfortunate, in my view, that the Grand Chamber did not stick to its position and backtracked on the insistence of the government, which provided the exact same argument that it had presented in Winter. The issue here is this a legitimate use of the clear and consistent case law condition for implementation of judgments of the court? I think if we start to look for, of course, the court is not always consistent and sometimes lacks clarity in the findings and in the motivation of the judgment. But again, there are internal and external ways of solving these problems. What should not be the solution that really we should avoid for the sake of the system itself, of the future of the system, is to allow courts to implement only those judgments that they find convenient. And if they don't find it convenient, they simply insist on their perspective, on their point of view, and ignore simply what the court has said. In fact, the practice, even after Winter, even after Newell in British courts, is very telling of what of this kind of reaction. If you read what the courts in England have said after Winter about the use of these compassionate grounds can entail. I'm reading, for instance, from the Court of Appeal Criminal Division's judgment from the 29th April 2015, so after Winter. The effect of the judge's order was that all life order was imposed, meaning that appellant had no prospect of ever being released. A whole life order should only be imposed where the seriousness of the offending is so exceptionally high that just punishment requires the offender to be kept in prison for the rest of his or her life. Central Criminal Court, 25th November 2016, so after Newell, after the reading of Newell, after the the position taken by the Court of Appeal. The sentence, therefore, upon the counts of murder is a sentence of life imprisonment. I decline to set a minimum term. The result is a whole life sentence and the defendant will die in prison. So the practice shows that nothing changed. Even after the reading of the Court of Appeal, even after that attempt to again repeat the arguments of the government in Pinto, saying that we misrepresented, we misunderstood national law. The fact is that the practice shows that nothing has changed, and the standard applied today is the same as in the pre-Pinto era. So, is this justified by the fact that we are interfering here with new issues, problematic issues, issues of political nature? Voting rights of prisoners is not something created by the court. It's not a right created by the court. It's enshrined in the letter of a protocol. So it's something that you cannot say that this is a creation of the court. Excuse me?
That's what the dissenters say.
Well, I know, because they could not accept that the court, in fact, in line with its case law, interpreted the convention and the protocols in accordance with the position of the Venice Commission, which is totally in line with previous case law. So it's an harmonious interpretation of the convention and the protocols that the dissenters could not accept. Take this example of Hutchinson. Parole for lifers, for people sentenced to life imprisonment, is not exactly the topic that you could say that is totally new in the case law of the court. There's plenty of case law of the court referring to this, well-established case law against many countries. It's not a British issue. So it's I think a little bit far-fetched to say, well, the court should not intrude in new domains, in new issues of political nature. Some of these issues are indeed based on the letter of the convention and the protocols themselves, and others result from well-established case law that was accepted by and implemented by Supreme Courts and constitutional courts all over Europe for decades without any kind of problem. On the second question raised, which is the opportunity and the convenience of having a second look. Well, the court is sometimes confronted with this problem of having to have a second look. And it has sometimes admitted that, for instance, when an applicant comes to the court saying the first judgment was not implemented, please take a new position. That has happened. Not frequently, but that has happened. And the court has an opportunity to really go into what has been the implementation provided by the national authorities. It takes a position, as it did, for instance, in a Swiss case, about
the adequate, more or less adequate way the national authorities implemented the initial judgment, and sometimes accepts, other times does not accept that kind of implementation. So it assesses the situation again in the light of what has been the implementation given to the initial judgment. And of course, the court in the highest formation, in its highest formation, the Grand Chamber has reviewed many times its case law. So it's something that is not written in stone, in a stone. It can be reviewed. The case law is evolutive, as I've mentioned, and the court has in many occasions adapted to the new times, to the new needs of European societies. So I don't see a need for a mechanism that would imply putting at stake the legal force of the judgments. The risk, again, is what we are now seeing, for instance, with the Italian Constitutional Court, which on a topic that is really not the most important constitutional issue that you can think of, on confiscation of property, has delivered a judgment in the Varvara case in 2015, March 2015, where they have said that from that moment on, they would not follow, they would not consider judgments of the chamber, any chamber of the court, as binding if they were not consolidated law, if they were not diritto consolidato. Now, what is consolidated law? Consolidated law. That's up to each judge in Italy to find out. Imagine the kind of uncertainty that this creates. Each judge in Italy has now the power to say that a judgment of the court, a chamber judgment of the court, is not consolidated enough, so therefore it will not be applied in a similar case. This, of course, creates a systemic problem in terms of the enforceability of the judgments of the court. Recently, we had a Grand Chamber delivering a judgment in an Italian case, De Tomaso, about preventive measures used in the fight against mafiosi. The statement of the court was very clear, finding that these preventive measures were in breach of the convention and the standards of the convention. Yet, there is a position already taken by the Milan court, which says that since there were a couple of judges who were not in agreement, since there were dissenters, and this is a Grand Chamber judgment, this Grand Chamber judgment is not considered as diritto consolidato. So there are already judges in Italy saying that it's not only a problem of chamber judgments, even the Grand Chamber judgments can be considered as non-consolidated and therefore as non-binding. You see the snowball rolling down the hill. So it's getting bigger. And the problem is really a systemic problem. It becomes, and Italy, we are talking about a founding father, a country which has always been friendly towards the court, as the UK, a driving force in terms of the development of the case law. And now we are confronted with this kind of reaction. So it's really something that is very, very worrying.
respond to yours question?
Yes, I'd like to. I understand the question was, how do we know what an exceptional case is? Because I was suggesting one of the criteria that could be used in the dialogue scenario I had in mind was exceptionality. I think that it can be done in this way. You start from the presumption that the routine is going along with a clear and constant line of the Strasbourg court, otherwise you'll have a rule of law problem. But that some cases you will break from that because the consequences of not doing that are quite substantial. So one of the criteria for exceptionality, I would say, would be that the magnitude of the consequences are particularly important. This case really matters for national law and policy. Animal defenders is a perfect example. Arguably, Al-Khawaja is another case, right? These are really fundamental features of the law. Now, that's the criteria that's been set out. I think it makes sense. I also think you should say that only the Supreme Court should be able to rule on exceptionality. I think that would be a further control on making sure that this doesn't get out of control. There are only about 100 and something cases, 120 or so cases that go to the Supreme Court in a year. They're fairly conservative about this kind of stuff. I don't think it's going to spin out of control. Hutchinson, I don't think Hutchinson was an exceptional case at all, and I said I agreed with your disposition of it. Hutchinson, effectively, the majority of the court said, look, because of the way the Human Rights Act works, we can read this provision of the Act in a way which incorporates Strasbourg jurisprudence. So we are admitting, we're telling you, the Court of Appeal says, our law is the same as what you want it to be. We use this Humpty Dumpty provision of the Human Rights Act to read the words that way. And you say, that's not good enough, it's not clear enough. The prisoner is not able to know what the prisoner's rights are. Effectively, I believe your claim is, if you're not going to amend the statute to make it compatible, you at the very least need to provide it, make it crystal clear in the Lifer Manual, and it plainly isn't. I completely agree. So the question for the court is it a fundamental change in UK policy and law to amend the Lifer Manual? No. They should have said, we're applying the Strasbourg Court, we're going to require the government to amend the Lifer Manual. But that's not, with animal defenders, that's a very different situation, I think.
Well, I think that's been a really fascinating discussion about the challenges that face the court, and we're really grateful to you for the candor and clarity with which you've made your argument, and grateful to Jeff for his very thoughtful consideration of the problem that faces Strasbourg. I'd like to thank all of you for having been here today. Thank you very much to both of our speakers.
Thank you.